Hello, my name is Alexander Zoya and I am an attorney with zeiler.partners. I will be talking to you about the Constitution of Arbitral Tribunals. When parties have concluded an arbitration agreement, the competence to decide the disputes covered by this arbitration agreement does not lie with state court judges anymore, but with arbitrators. And arbitrators are private individuals. But how do private individuals become arbitrators? Who chooses which person should be legally upgraded from basically just anyone, you, me, to someone vested with the authority to render a final and binding award, which is recognized by almost all states around the world? Well, essentially, as almost always with arbitration, it's up to the parties. Parties choose arbitrators. But before we go into more detail here, we need to find out how many arbitrators are actually needed to decide a dispute. In practice, I'd say it's almost always either 1 or 3 arbitrators. And that makes sense, as such an odd number prevents a split vote. Now, theoretically, there could be more than 3 arbitrators if it's an odd number. However, there are no real reasons why one would need more than 3 arbitrators, and many reasons why one would not need more than 3 arbitrators. Most importantly, costs. More arbitrators cost more money. So let's say the parties have agreed on 1 arbitrator. This is our first scenario. How do they choose the person to become the 1 arbitrator for their dispute? Well, again, they have to agree. And that, of course, will quite often be difficult, as disputing parties are most probably not on the best speaking terms. So if the parties cannot agree, someone else will have to choose the arbitrator for them. And now we have to differentiate between 2 kinds of arbitration. First, arbitrations administered by an arbitral institution, or second, so-called ad hoc arbitrations, where no such institution is involved. As regards our first alternative, the institutional arbitration, the institution comes to the rescue of the undecided parties. The institution usually has a panel of experts that are able to pick a well-suited arbitrator for the parties. As regards our second alternative, the ad hoc arbitration, the solution will depend on where the arbitration is seated. Usually the state courts at the seat of the arbitration kind of take on the role of arbitral institutions and support the parties in choosing an arbitrator. In Austria, the Supreme Court, for example, chooses the arbitrator for the parties in such situations. Now, another scenario. The parties have agreed on 3 arbitrators. This works differently, as now each party selects 1 arbitrator and the 2 selected arbitrators then appoint the 3rd arbitrator, the so-called chair. So party A selects arbitrator A, party B selects arbitrator B, and arbitrator A and B collectively appoint arbitrator C, who has the final vote, if arbitrator A and B have different ideas about the outcome of the case. What is important here is that all arbitrators have to be impartial and independent. And this applies to the chair as well as to the party-appointed arbitrators. So while party A has appointed arbitrator A is not party A's arbitrator, it's just the arbitrator appointed by party A, but as arbitrator completely independent and impartial. Sure, you will pick an arbitrator that you think shares your legal view on specific topics, or someone who has substantial knowledge in a certain area of law. Still, all arbitrators have to be impartial and independent, otherwise there could be severe consequences. Another important question is, who can become an arbitrator? What are the requirements other than the parties choosing you? Well, theoretically, anybody can be appointed, provided that he or she has full legal capacity and is a natural person and not a company, which of course makes sense. Other than that, there are usually no general requirements. Well, there's one specific rule in Austria saying that active state court judges cannot act as arbitrators. In practice, however, you will not just pick any random person off the street to be your arbitrator. Parties usually appoint lawyers or law professors. In certain disputes, it might even be worth considering not appointing a lawyer, but a non-legal expert in a specific matter. One important advice when it comes to non-legal experts sitting as an arbitrator is that at least the chair should be an experienced arbitration lawyer, because arbitrators not only have to decide on the substance of the legal and factual disputes, but they also have to conduct the arbitral proceedings, which can be quite tricky sometimes. Well, as always, reality can come up with much more problems than would fit into a 6-minute introduction video, but I hope that I have explained the basic principles for the Constitution of an Arbitral Tribunal somewhat understandably. And that's it for me. Thank you for watching.